Yeah, okay, perfect. So we are co-hosting the meetup today with InvestUp group with Chicago. I hope he was able to join us today. We have an incredible presenter to us with us today. It's Peter Fisher, who is a securities attorney with Clark Hirsch firm. He's been with the firm and doing real estate and corporate practice for many years. He's an experienced attorney who's done thousands of transactions, and his clients include developers, operators, syndicators, private equity providers, investors, and lenders. Peter's practice involves all aspects of real estate industry, including acquisitions, dispositions, equity investments, syndications, fund formation, development, JVs, leasing, financing, and many other things. Peter lives in Venice, California with his wife and young son. And in his free time, he enjoys taking pictures, sailing, surfing, and traveling with his family. I think most of us would want to travel these days, but probably restricted. So that's probably on everyone's mind. When can we travel freely next? A few housekeeping things. So this content tonight is solely for educational information purposes. This is not considered an advice in any shape or form. I'm sure you can read the rest. In terms of housekeeping, we typically ask folks to mute themselves. Peter suggested we make it interactive, so if you want to ask a question, just mute yourself, or feel free to type in your question in the chat box and I'll ask Peter. If you have any questions for me, feel free to reach out to me. If you're looking for recording, we typically share it within the next 48 hours. Our next meetup is scheduled for November 12th, and we will have Ketan Patel talk about capital raising fundamentals. And Peter is actually going to touch up on some potential new laws that will hopefully, as Peter mentioned earlier, may be implemented. I don't know when, but we'll ask Peter to talk more about that. If you need to reach out to me, this is my contact information. Also, for those that are starting out in real estate and looking to find out what type of real estate investing niche is right for them, I put a course together recently. It's available on Udemy, and it's called How to Choose the Best Real Estate Investing Niche. If you just type that on udemy.com, the course will come up. Or if you need my help finding it, just email me and I will send you the link. Chike, are you on the line? Would you like to talk for a few minutes?
Yeah. Hey, Chike here. Thank you everyone for joining. Definitely glad to see you out here. We have some great content for you guys tonight, and I'm just representing the InvestUp Club. We have meetings on a regular basis, so feel free to check us out. If you came via that link, then you can use the same webpage to find the other events that we are hosting as well. So thank you guys.
Awesome, great. And I would like to pass the mic to our presenter for the night. Peter, the stage is yours. Please take it.
Great. Well, thank you very much for having me. Again, I am both a real estate and securities attorney at the firm of Clark Hirsch in Los Angeles. To add to the disclaimer, I am a lawyer, but I'm not your lawyer, at least not yet. Take this as just general education. And I think either I can give you my information at the end, or it will be passed along to you. And just feel free to reach out. Always happy to talk to new folks and answer some questions, and find ways that we might work together. So as I said at the outset, I really do want this to be interactive. I don't have a PowerPoint that I'll just drone on about, but feel free to stop me at any point. And I'm not quite sure what what folks in the audience are doing, if you're new syndicators, if you're experienced. So again, I'll just sort of speak generally, and hopefully it'll be, maybe too basic or over the heads for some, but feel free to stop and ask any questions. So, obviously when you're talking about syndications, you're talking about a real estate transaction, or at least in this case we are, but really a syndication, right? I mean, it's pooling of money for a common purpose, a common project. And it's really pooling money from passive investors, and the sponsor or promoter is going to be the one active and making all the decisions, right? As opposed to a joint venture where you might have one person or one group providing all or 90% of the capital, but they're not going to let the sponsor just do whatever they want, right? They're going to have decisions on when you can sell. They're going to want a budget. So in this case, really we're talking about grouping 10, 20, what have you, people who are, you've all probably heard the term LP, right? Passive limited partner, with virtually no voting rights, or very, very limited voting rights. I don't know if anybody here has invested in a syndication or again has sponsored a syndication, but the manager basically raises the money, and then you are sitting back and letting the manager, the sponsor, buy the building, renovate the building, lease up the building, what have you. And there's really no way for you to come in and say, hey, I don't think, I don't approve a sale right now. Maybe there's, some ways if the manager commits fraud or some other very bad boy type acts for the manager to be removed. But, barring that, it's really the manager making all the decisions and running the property. And that's sort of a prelude as to say, which is why, right? It's not just a real estate transaction, it's a securities transaction. Because what sort of the definition of a securities in layman's term is when you are putting money into a project for a common purpose, and the other party, right, the promoter is in control. So if you have those features, that is with, outgoing into the legalese, right, that's what a security is. And that's why when you do a syndication, you not only have to worry about real estate laws, but you have to worry about the securities laws. And that's where sort of the corporate side and all of these SEC regulations that you've probably heard of, Reg D, 506B, 506C, sometimes Reg A. That's why there's this overlay of securities coming into what otherwise seems like a real estate transaction. So I don't know if that, if there are any questions so far. Everybody, we're all on the same page. Okay, great. I've got, let's see, looks like, okay, so no questions in the chat box. How do you get started in syndication? So we'll talk about some of those things. So because we're in the world of securities, you have to deal with the regulations and the securities regulations, and you start from the point of, okay, if I'm doing a securities offering, I have to either, right, do an IPO, an initial public offering, which, is like what Apple or GM, nobody in the sort of private real estate world is going to go through the process of doing an IPO and getting their offering approved by the SEC and reviewed. And it's prohibitively expensive, prohibitively time consuming. You'd never close a deal, right, if you did that. So you have to have a private exemption. Otherwise, you would have to do that IPO. So the main ones that everybody uses, in particular in the real estate world, are under Reg D, and they're 506B and 506C, as in Charlie. And again, sometimes some people who are trying to raise larger pools of money, you might use Reg A or A+, and we can talk about that if you have questions. But I think, 90+% of real estate syndications are done under Reg D. And 506B is and has been the most common one. And you may know that under 506B, you cannot generally solicit, you cannot advertise, and you can have up to 35 non-accredited but sophisticated investors, although for reasons that we'll go into, we counsel our clients to not have any non-accredited investors, whether you're under 506B or 506C, if you can avoid it. And that's because there's increased disclosure and increased financial reporting requirements that if you could, you'd just like to avoid. And even though you can have these non-accredited investors, it's always a better idea to just stick with accredited investors if you can. So the other one is 506C, which you may have heard under the Jobs Act came into play. And that does allow general solicitation. You can post on LinkedIn, you can advertise your deals on Facebook, but you have to go through the step of, first of all, you can only have accredited investors, and you have to go through the step of verifying that those investors are accredited. So under 506B, you can just have a questionnaire and somebody can sign it, absent you really knowing that they're not and just saying, wink, wink, and sign this. But they basically self-certify. They sign a certificate that says, I'm accredited, I can invest in this deal. Under 506C, you can't just take their word for it, right? You have to take extra steps to verify that they're accredited, and there are certain sort of so-called safe harbor steps where if you do these things, then nobody can come back and say that you didn't verify these investors. And the general ones, again, you may know, getting a letter from a lawyer or a CPA. There are several third-party services. The biggest one is Verify Investor, which was actually started by a former colleague of mine at Sherman & Sterling and his partner, and many of the crowdfunding sites that accept only 506C offerings use sort of Verify Investor as a back end, and that's how you can get that done. Obviously, there's an extra cost, a little bit of extra time, but then it does allow you to post your deals on Facebook or put them in the Wall Street Journal if you want to. So that, since really 2012, and I would say since crowdfunding, the equity crowdfunding platforms, Realty Mogul, CrowdStreet, and those sites have been proliferated. I would say I still probably do 70% 506B deals. I think, clients who have an investor database over time, sort of still want to utilize that and not go the verification route. And I think that sort of country club, building sort of your homegrown investor database is still somewhat of a preferred method for a lot of people. But I have obviously a proliferation of 506C deals, and we're interacting with the crowdfunding sites regularly. And in fact, my firm and I represent a couple of those crowdfunding sites and some newer platforms. So it's kind of cool to be on that side and be involved in the technology too.
Yeah. Peter, I have a few questions.
Oh yeah, absolutely.
If you don't mind. So
sure.
You mentioned that preferably you want your clients to stick to accredited investors. Is there reasoning behind this?
Yeah.
And if so, why? Yeah, if you could go into that.
Yeah. So the main reason, right, is because there are increased disclosure requirements and potentially increased financial reporting requirements, which can make your transaction much more expensive and take up much more time. So the general rule is if you have only accredited investors, you are not required to have a PPM, a private placement memorandum. You know, again, for most of our deals, and we can talk further about this, most of our deals we do. They're large enough. You know, the sponsor may not have a very close relationship with all the investors. So we do usually recommend it, but by law, it's not required to have that kind of disclosure document if you have all accredited investors. If you don't, if you have one, even one that is sophisticated but not accredited, you must have more robust disclosures, and so you must have a PPM, which again, you know, if you have a syndication and you're doing it with, you know, 5 or 7 or even 10 of the sponsors' investors who have invested with that sponsor before, they're all accredited, they know the sponsor, you know, and maybe you don't need a full private placement memorandum, but you couldn't do that if you had sophisticated investors. There's also times, depending on how much money you're raising and other things, when you need audited financials instead of just, you know, unaudited quarterly reports or what have you, end of the year unaudited financials. So it can make the deal much more expensive.
Sure, makes sense.
In addition to that, you know, in doing this for a very long time, it is often smaller investors who cause the most problems, right? You know, if somebody's going to invest $1 million into your deal and they're accredited, the chances are pretty good that they vetted you, you know, they're not just finding you on a whim. And if something goes wrong, they're going to work with you, as opposed to, you know, the doctor's grandma who you happen to meet, who, you know, somehow invested her last $25,000 with you. And of course, you know, this is not always true, but it just, in my experience, and I'm, you know, talking to several other attorneys, it is often smaller investors who can cause the most problems, and also investors who don't do this on a regular basis and don't understand sort of the life cycle of a syndication.
Sure. Peter, a few more questions came in, and I can read them for you. Does LP have any legal liability exposure due to lack of compliance from GP part?
That's a very good question, and one we represent investors and sponsors. The answer is, or should be, no, right? Especially in a true limited partnership, you have a general partner and limited partners, as opposed to, say, an LLC, which is a manager and then members. In either of those two structures, the members have liability protection. In an LLC structure, the manager also has liability protection, but in a true GP, in a true general partnership, limited partnership structure, the general partner doesn't have any liability protection. So now, is that to say, can I promise an investor that they won't get named in a lawsuit? No, but I have never heard of a situation, unless there is collusion or fraud on an LP's side, where an LP, a true passive investor in a syndication, ever, you know, had liability in a lawsuit coming from that property. Now, of course, you know, you can lose money in a syndication, but there is a liability protection, and often in documents there will be indemnification or, you know, other protections for LPs from the sponsor if they ever got named.
Peter, does it matter, on the same note, does it matter who gets sued? Because, you know, a lot of syndications are structured in a way where the investment itself, and I'm talking about individual property, not the fund, is an LLC, but then it has, you know, the split between GPs, the management company is one entity, and then the LP is another entity. So does that give an extra layer of protection to LPs, or it doesn't?
For the LP, no. I mean, look, I think there's maybe, for example, if you are an investor in a syndication and you invest through an entity rather than personally,
Mhm.
there is a slight, sure, there's an additional entity, but
Yeah.
even if you invest personally and you're just totally passive, I cannot imagine a situation where, unless you're signing on the note, unless somehow you've pledged your interest,
Yeah.
I can't imagine a scenario where that LP would have any liability. Now, again, they may get, if there's a lawsuit at the property, they'll probably name everybody that they can find. But again, I can't imagine a scenario where, I'm sure somebody's going to email me after this and give an example of when it happened, but it's hard for me to picture how that person could have liability.
Makes sense. Another question came in. If we only have 1 or 2 accredited investors, looks like there is no need for a full-blown PPM. What kind of disclosure agreements are needed and who prepares them?
Yeah, I mean, again, so yes, it's true that you don't need a PPM, but there are other reasons, and again, most of the time in our deals we have one. So think of a PPM as a big insurance policy, right? Even if you don't need to have one, if you have a whole bunch of disclosures and you've told all of your investors that this property was built on a gas station, somebody fell off the balcony and died at this property before, and you've told them all of this, and then this person's family comes back and sues the entity, none of the investors can come back and say, well, you didn't tell me that. Yes, I did. It's on page 60 of the PPM, and you signed a subscription agreement saying, you got it, you read it, you had the opportunity to ask all the questions you wanted. Now, I think, in many of our deals where there's 20 or 30 investors and, maybe 5 of them have invested with the sponsor before, and then there's other people who have been introduced, and the capital raise is 2 to 3, 4 million, we would still say, look, you have investors who haven't invested with you before, you don't really know them, there's a lot of them, it's a pretty significant amount of money you're raising, so you should do a PPM anyway, right? Compare that to a deal where you're raising 500,000, 600,000, or 250,000. You have 4 investors who have worked with you before. They're all accredited. Then I would probably say, don't do and a lot of this is optics, right? So if your investors are expecting a PPM, the market is dictating that's the package, then you should also do a PPM. But if you have 5 investors and they've invested with you several times and they're not going to want a PPM, then absolutely we would say don't do a PPM, do your operating agreement, and then have a subscription agreement, and maybe attached to that subscription agreement have an exhibit with the 5, 10 major disclosures that you want to make about multifamily property is dependent on rents, the business is totally dependent on the principals, and if one of them is not there, your investment may be lost, that kind of thing. And that's what we call a PPM light, which is no full PPM, but a subscription agreement with a risk disclosure exhibit.
Thank you. That was helpful. Do you mind talking about the recently or not so recently applied changes to accredited investor status and what it means for the industry?
Yeah, sure. So as I said, at the outset, one of the things to talk about and are the current developments in the industry. And I was all set to give you my, beware, don't do this. The SEC is going to come down all of this unlicensed broker-dealer activity. And look, I mean, there's always a risk, again, when you're doing securities transactions that, this is an offering, then the SEC is going to monitor both the offering piece and also like the broker-dealer piece, who you are using to raise this money for your offering. But the recent developments, as was alluded to, both in terms of broadening the accredited investor definition, and now coming into the proposed regulations for a finder exemption, and I'll describe both of those, but it does seem that the SEC is really focused on the actualities of what are going on in the industry, and assisting, especially I think in the pandemic, helping smaller businesses and operators raise more capital. It would be kind of a bad look to start cracking down on all of these capital raisers in the middle of a pandemic when people are cash starved. So talking about the accredited investor definition expansion first, which I think is the sort of less exciting, if you will, of the two recent developments, although still, mildly exciting, I would say, getting more exciting. So for a long time, the accredited investor definition has just stayed static, right? You may know it's generally 200,000 a year or 300 with a spouse, $1 million, of net worth minus your primary residence, and that's sort of been the definition for years and years and years. And people have said, well, the SEC is thinking about broadening it. They ought to broaden it. People complain that it's very elitist, that the crowdfunding has really opened up, these private sort of old country club real estate deals, and now everybody should be able to get in. And look, there's some truth to that, but when you think about it, since the 30s, right, when the securities laws were first coming into play in the U.S. after the crash of '29, they really worked very well. And not only for us, the U.S. investors, but attracting capital around the world is due, in the U.S. is due in no small part to the stabilization of the securities and the capital markets here in the U.S., right? So for all the sort of flack, I think, that the SEC gets, that I think they've worked pretty well. So the recent expansion in the accredited investor definition is the reason I say it's somewhat of mild excitement is because it's really a very small incremental advancement. And when I first heard about this, I sort of brushed it off as the SEC isn't really doing anything in this realm, because basically what it is now they've added a qualification for people who have a Series 7, and other securities licenses of that ilk, right? So you can now have a license, an accreditation, but not have the net worth or not have the annual salary that previously was needed for the accredited investor definition. But the universe of people who have those licenses is not very big, right? So you're probably not suddenly going to be able to go raise a whole bunch more money because you have a bunch of stockbrokers. I mean, maybe some people, right? But again, these are people who are on Wall Street. They're financially savvy. So that's not a very big, in my mind, it's not that great an expansion. Now there is one other category for larger entities, and I had a client who had to bring in sophisticated investors right before this passed, because they have a large, a much larger institution as a sponsor, and they wanted their employees to be able to partake in the deal, but many of them, lower level employees were not accredited. So they had to, go do audited financial. I mean, they really wanted their employees to partake, so they took on the extra costs and extra time. And of course, a couple of months later, the accredited investor definition was broadened, and now it also includes knowledgeable employees. So that, I think, for some of the larger sponsors is a really big change, because now their employees who aren't accredited but who have worked with the sponsor and know the company, they can invest without slipping into the sophisticated category. But again, the sort of smaller first-time sponsors are not going to be doing syndications where they have 10 knowledgeable employees.
True.
So that's
Peter,
why, yeah.
Go ahead.
Well, that's why I sort of reacted to the broadening of the accredited investor definition, with somewhat mild excitement.
Sure, makes sense. We have a question that is relevant to the topic you're discussing, so sorry for the interruption.
Sure.
Matt is asking, can we dig into how SEC defines non-accredited or sophisticated investor, and what hurdles should be met if we as sponsors want to include friends and family who do not meet the accredited investor requirements?
Yeah, so that's a good question. There is no official definition of what a sophisticated investor is, but over time and with underlying regulations, no action letters and things like that, basically a non-accredited but sophisticated investor means somebody who has the knowledge and experience, whether on their own or through an advisor, to invest in these types of transactions, but they just don't have the sort of dollar requirement to be accredited, right? So they are experienced, they understand syndications themselves, or they have somebody like you, or a lawyer or a financial advisor through which they can gain an understanding and ask the right questions. Now, how do you know that? It's a really good question, and the only thing that you really can do is, in addition, if you're going to have sophisticated investors, in addition to having an accredited investor questionnaire, you have a sophisticated investor questionnaire where you ask what that person's experience is, if they have an advisor, what the name of that advisor is, how many syndications they've invested in before, that kind of thing. And again, they're self-certifying, so you're generally taking their word for it, unless you know otherwise. And I think, in addition to increasing your costs, your legal costs, and maybe your CPA costs, you're also increasing your risk that somebody like that will come in and lose their money and not really have understood what they're doing. Now, if they're employees and they work for you, or they're somebody's son who isn't accredited but has 3 generations who have invested with you before, but I do think it increases your risk.
For sure.
So,
sorry, Peter, if I just follow up to that.
Oh, sure.
Les, I imagine like the first time syndicators, those are kind of like the investor base that they're dealing with, right? It's like their network. And so it's, from what I'm hearing from you, it's obviously you'd love to avoid it, but some of the first time, the newer, greener syndicators, that's probably the people they want to bring along for the deal. So how do they, other than the questionnaires and such, and some of these folks might be borderline, do you see those syndicators either take that risk, or do they hold off and try to build their investor base and gear it more towards, they kind of wait on those deals to get more of an accredited investor base? Like how have you seen people deal with that?
Yeah, that's a really good question, and it's hard, right? I mean, if you're trying to get your first syndication done and you have a bunch of people who you know, maybe they're not all accredited, but they also are excited about doing a deal. And so what do you do? I mean, I see people do it many different ways, but I think, what I would say is get together with somebody who is already doing syndications, try to co-GP a deal, try to build your network, try to, meet other people in the industry, and really look, clients are going to do, and syndicators are going to do what they're going to do. But in my mind, it's much better to, the best or the only thing worse than doing no deal is doing a bad deal. And if you're a first-time syndicator and it's your first deal and you bring in your grandma, your best friend's son, and everything goes bad, it's going to be really bad for you on many levels. And so if you get experience and you co-GP and you're an LP in several deals and you understand the cycle and you understand the documents that you had signed, you build a great team, a great CPA, a great lawyer, all these things. I think there are a lot of ways to do this and get involved in the industry and build your knowledge and your network before you do your own first deal and you have to cobble together a bunch of people who are not sophisticated or not accredited. Now, that's not to say that it can't be done and it hasn't been successful. I think the other thing is, right, again, it's more expensive to do a deal with non-accredited investors, and first-time syndicators often don't have deep pockets to spend a lot of legal dollars or do a $35,000, $40,000 audit of financials every year. So I see it done many different ways, but I do tend to tell people who are trying to get into the business to do other things and co-GP and build up their network before really trying to go buy a first property.
Makes sense. Thank you, Peter. I think we interrupted you. You were going to talk about the new proposal that may potentially take place soon.
Right. So the more exciting thing, I think, is just recently on October 7th, the SEC and again, which is after I put these sort of talking points together, I was all set to come in here and talk to you about all of these subpoenas and the focus. The SEC is really cracking down on unlicensed broker-dealer activity, and suddenly the SEC has now come out with a proposed codification of a finder exemption to broker-dealer licensing. And if anybody else is from California, you know that we have such a thing on the state level here in California, but there's never been a federal regulation saying that you could be a finder as long as you didn't do things that rose to the level of a broker-dealer without going and getting a broker's license. And for a long time, this has been a big question. There's some no action letters. There's the entertainer Paul Anka was sort of in hot water with the SEC, but there was a no action letter with respect to him that kind of people thought there might be a finder exemption. But now they're actually looking to, and I think they will probably, maybe as early as next year, once the election gets out of the way, they actually will be codifying a finder exemption. And what that means is, so basically right now, if you want to hire somebody or a company to be an intermediary, I think, Matt, you were asking about how do you, get investors? Well, one way is to hire somebody to raise money for you. And up until, or still, you had to find somebody with a broker-dealer license, right? I can't go out and raise capital for a syndicator and get paid a transaction-based fee, meaning like a percentage of what I raise, without a broker-dealer license. That's about to change. So that's really, really exciting, with a bunch of caveats. What the SEC has said is, we are looking to promulgate regulations that allow for 2 tiers of finders. And basically what a finder is somebody, as the word sounds like, it's somebody who finds money, right? But doesn't negotiate, doesn't, provide documentation. They don't do the things that broker dealers really do, which is really get involved in the negotiation, distribute materials, that kind of thing. So the SEC has said, we are proposing that there are 2 tiers of finders, and basically they are differentiated by what the activity of these people, what they're going to do. Number one, both of them, both tier 1 and tier 2, they're called, they both have to be natural people. So you can't form an form an LLC to be a finder, right? It has to be an individual, which interestingly enough is exactly the same as what the current California regulations say. Tier 1 finders can basically, all they can do is give you a list of potential, you being the sponsor, give you a list of potential investors and make that, you're not even like making the introduction, you're really just saying, here's a bunch of my friends, or here's people who I think would be interested in investing with you. And the tier 1 people can do that 1 time per year, right? So, and that's basically, I mean, there's a little bit more nuance, but that's basically that's it. That's what the tier 1 people can do. They can't get on the phone. They can't, if I want to call Matt or Joe and say, hey, I have this really great deal, let me tell you, here are the terms, can't do that. The tier 2 people can do a little bit more, right? They can actually reach out, they can make connections, they can distribute some materials. They still can't negotiate, right? You're still not able to do what a true broker does, edit the sponsor's pitch deck, but you can be a little bit more involved. There's not this 1 time per year limit, but the trade-off is that you have to get a written disclosure to both the investors and obviously the sponsor, and you have to get signed acknowledgments from these investors of the sort of finder activity. And there's a little bit more to it than that, but basically those are the 2 tiers of folks that the SEC is saying, okay, here's what we're proposing, this 2-tiered system of people who can now go out and raise money for sponsors without being licensed broker dealers. And we have lots of clients who have asked, hey, I know, especially being in a place like LA or New York, we're connected to so-and-so on the Clippers or the Lakers, and they know a lot of people. I have a client whose partner is a former NFL player. Obviously he knows other players and managers, and being in LA, there's lots of entertainers. There's lots of money around and people with influence, right? But they're not broker dealers in the sense of they don't have a broker's license. And I don't mean real estate broker's license, I mean securities broker's license. So it will be the case, I think, pretty soon that these people can work with, these sponsors who are our clients and other people's clients. But again, it's not like all of a sudden you can use anybody to raise money and they can say or do anything. there are going to be very strict guidelines. And the other thing, again, is the investors, all the investors, either in tier 1 or tier 2, must be accredited. So you still can't go out and find a bunch of sophisticated investors. But it is really, I think, sort of codifying what is already going on. You know, a lot of my clients before this happened and come to me and they said, well, can we work with this sports figure, you know, and he's asking for, you know, X% of whatever he raises. And you say, no, you're, you know, rolling the dice, and well, he's done it with 4 other sponsors. And look, I mean, people have been doing this for a really long time and it's very prevalent, but up until recently, you know, as was evidenced by these recent SEC investigations, it was fraught with, you know, a lot of danger. And now, at least once these rules get, you know, codified, there will be a lot of activity. Although, you know, I wouldn't want to be the first person or two who did it and didn't follow the guidelines. But, and again, it's obviously not carte blanche to go and, you know, hire anybody to raise money, but it is, I think, a real step towards broadening, you know, what's going on in the industry.
And Peter, I don't know if I missed it, in terms of tiers, are they self-defined?
What do you mean by self-defined?
Meaning the person who is looking for that finder's fee, do they define which tier they belong to, tier 1 or tier 2?
Well, they basically, I mean, it's basically what activities are you doing, right?
Mm-hmm.
So if you're in the realm of, hey, I'm just going to do, you know, this one transaction and tell my friend who's a real estate sponsor, you know, oh, you should talk to these 5 people, and I am not going to, you know, have any disclosures, and the sponsor's not going to have any disclosures, and I'm not going to get an acknowledgement from these investors, you're in tier 1. And really, if you're doing anything else, right, you're in tier 2, and you've got to get these disclosures, you've got to get acknowledgements from the investors. So it's, you know, the tier 1 is pretty narrow.
So sounds good. So it is self-defined to a degree.
Yeah.
Sure. We've got a bunch of questions come in.
Sure.
So let me read the first one. Felipe is asking, it was my understanding that if no PPM, that implies that all partners must be active, otherwise PPM is needed. This PPM live that you mentioned, is it sufficient for SEC?
Yeah, so again, if you have all accredited investors, you do not need a PPM. That the law does not require you to have a PPM. But I've got probably 7 offerings on my desk right now. All of them have PPMs, and of the, I don't know, 100 that I did last year, you know, maybe 5 didn't, right? And again, that's the size of the offering, who your investors are, and what the market is going to expect, right? So especially like if you're posting on one of these crowdfunding sites and all of the other deals on this site have a PPM, they have, you know, full subscription, and you don't, even if technically you're complying with the law, you know, you're not going to be very successful if your investors look at your deal and they don't see a PPM, so they don't want to invest in it.
Wouldn't the crowdfunding sites be enforcing it? I mean, if they want to have quality deals for their investors.
Yeah, I mean, I would think the crowdfunding site would probably say, why don't you have a PPM? You know, but I mean, I haven't worked with every crowdfunding site, maybe, and I do think I've seen some deals without full PPMs, but it's rare. I mean, if you log on to Realty Mogul or CrowdStream, you know, every deal has a PPM, a subscription agreement, and so, you know, and even if you're not doing a crowdfunding deal, right? I mean, people who look at these passive syndications, they expect to get a PPM, I think, generally.
Yeah.
So
makes sense.
yeah, and so the active passive part of the question, that's what I was sort of alluding to at the beginning, right? If you have a JV investor and they have a whole bunch of major decision rights and they're active, that's not a syndication, really. I mean, it's very rare, and I don't know that I've ever seen one where you have a true syndication, but every LP, right, has a say on when the property is sold. I mean, if you think about it, getting 30 people to unanimously, or even like a supermajority or majority vote on when the property gets sold, and you as a sponsor, you know that you want to run your business, you know the market. So that's sort of the difference between active and passive. But if you have non-accredited but sophisticated investors, you have to have a PPM. So I hope that's a long-winded answer, but hopefully that clears it up.
I think that was good. Rick is asking, does one need to have a current Series 7 63, or would expired one work in this realm?
Oh, to be an accredited investor under the new definition?
I don't know. I'm assuming Series 7 and 63. Rick, maybe you want to clarify. Are you referring to raising capital or being an investor? Rick, you're on mute.
Yeah, I just unmuted. No, Series 7 is something I acquired back in '82, and I let it go in '98. And my 63 is a blue sky law. So you could buy a license in every state you want to do business in. You have to have the license in each state that you do business with. This is securities. And the Series 7 is what Peter was mentioning earlier. And I also have a current real estate license that I've been keeping up with the continuing education. I've had that for over a third of a century. And I've had Series 7 or former life, health, and accident. I don't think that would apply. But I'm just wondering if the real estate with the former Series 7 63, would that have any advantage to be in the sophisticated category, or does it have to be a current Series 7?
You're talking about to get to the level of an accredited investor.
Right.
Yeah, the real estate license is not one of the items, at least not yet. Look, they could expand the categories of licensure that gets you into the accredited land, for lack of a better term. But no, if you aren't currently licensed in one of the categories, and it sounds like your Series 7 is no longer active, then that would not get you into the category of accredited.
Yeah, that's what I was thinking, but I just thought I'd air that out.
Yeah.
Thank you.
Sure.
Excellent. Next question. How does this work with raising money from SMB? I'm assuming it's small businesses to invest versus institutional, or are they the same? Do we need clarification? Jason, Jason, do you want to help us clarify your question?
Yeah, so I know that, good evening, everybody. I know that I've been raising money from individuals, from accredited investors, and I just wanted to know if the rules, or you maybe find it might be easier from raising it from working directly from small and medium-sized businesses versus institutional, because I'm looking at a few larger deals, and my partners are going after institutional money, hedge funds, private equity. But I wanted to know, would you consider small and medium-sized businesses working with the actual businesses, not just the individuals, to be the same as institutional, or is it different?
Well, look, I think it's always easy on sort of the two ends of the spectrum. It's always easier, I think, when you can deal with institutions, whether they be family offices, hedge funds. It's always nice to go out and get one check rather than 30 or 40. Of course, the caveat is that you give up a lot of control when you're doing more of a joint venture, right, versus syndication. I think your question is, are there sort of non, high net worth individual types, but that are more smaller companies that don't rise to the level of the institutional investors?
Yeah, exactly.
Yeah.
Because I know a few small business people that want to invest, but they don't really meet the criteria of accredited investor. But through their business, they have enough that they have the money coming in. And so I wanted to know if like, I was trying to see if there was a way how to get around that if the businesses invest versus the individual.
Got it. So basically, if an entity, right, which is what I think you're talking about, so that, let's say the small business person owns or runs their business through a corporation or an LLC. If the LLC invests, in order to determine if the LLC is an accredited investor, you have to look through to the owners. So if an LLC has one owner, right? Let's say an LLC has 10 owners and any one of them is not accredited, that LLC is not an accredited entity. Now, there are exceptions if that entity is making, not even sure, in excess of 10 million. There's some very high level, right? If you think about it, like, a fund may have passive investors, or even a public company may have somebody who owns stock that is not accredited, but the company itself is so well capitalized that it has sort of the financial wherewithal. Most small businesses don't rise to that level, and so you'd have to look through to the individual. And if the individual wasn't accredited, then the business wouldn't be.
Okay, that makes sense.
You may need to take those on a case-by-case basis, but my guess is if you're talking about sort of small, average business, then you're going to need to look through to the individuals.
Cool. Next question.
Thanks.
Excellent. Next question. If someone has Series 7 TO, can they work independently of the firm for which they have obtained the license under?
Is that question regarding the investing as an accredited investor or as a broker dealer? I definitely don't think your firm is going to want you to go out with a license that is affiliated with their company and raise capital.
Yeah, it is related to raising capital, but I got clarification.
Yeah, you'd want to check with your company. Most certainly, I think the answer would be no. But
got it. Thank you, Peter.
Yeah. So quick follow-up on that. Aside from, let's say, internal firm policies, more on the, let's say, SEC side, assuming your firm has no issue with it, which of course, from an internal compliance, that might be something hard to overcome, but assuming that your firm has no issues with you going out and doing some capital raising, would the SEC view you differently as an individual, since you're not like a broker-dealer entity, you're just an individual?
Yeah, I mean, look, if you have a Series 7 or similar license, your license is affiliated, right? I mean, you are not a broker-dealer yourself, so, or I don't think. So your license is affiliated with somebody who actually has the broker license, with an entity that hangs that broker license. So certainly you can't be a broker dealer without your company. It's a good question as to whether you could raise money, assuming, or when these finder regulations come into play. If you are affiliated with a broker dealer, can you still raise money as a non-broker dealer as a finder? And the answer is, I don't think so, but that's something I'd have to check. And again, I'd be very surprised if your firm would want you to be doing that. but it's an interesting question.
Yeah, no, it makes sense what you're saying, Peter. So yeah, I'm sure you're right. Guys, feel free to unmute yourself if you want to ask questions. I don't see any more in the chat box, and Peter has certainly answered a ton and brought a lot of value to the group. Are there any other final questions? Peter, it sounds like you've done a phenomenal job because all of the answers the group had
I
have been
gave
answered.
everybody all the information they'd ever need.
Yeah, and beyond. Thank you so much. Do you have like a virtual business card, or do you want to post your contact information if people want to reach
I
out?
don't have a virtual business card, but I will put my email in here.
So guys, in case you want to reach out, Peter just typed his email in the chat. Feel free to reach out to him directly.
Yeah, absolutely. Happy to answer further questions. If anybody's putting a syndication together, they want to talk about putting a syndication together. We're always open to chatting with new folks for an initial consultation, no charge. Especially if it comes from this group, I definitely appreciated the opportunity, and be happy to answer any questions, further questions.
Awesome. Excellent. Thank you so much, Peter. Thank you, everyone. Have a great evening.
Thanks, everybody.
Take care.